give a short ruling. This matter is listed for an appeal hearing against the decision of Deputy President Tudor on the 23rd of March 2023, refusing the appellant permission to apply for judicial review against a Stage 3 panel decision taken by the respondent in disciplinary proceedings against the appellant. The Stage 3 decision was to the effect of refusing a challenge by the appellant to a Stage 2 panel decision, as a result of which the appellant had been found to have committed sexual misconduct against a fellow student on the 8th of September 2021. Lord Justice Coulson granted permission to appeal against the refusal on date to be inserted. The appellant, in his written submissions drafted by Miss Braganza, King's Counsel, identified in the skeleton argument that the appellant's invitation was for this court to proceed today to a substantive hearing of the full merits of the case. That skeleton argument postdated the skeleton argument of Miss Slarks for the respondent. It is common ground that we could accede in principle to that invitation today, following a line of authorities including Sandar 2011, EWCA Civ 613, and Bindlos BYNDLOSS 2015, EWCA Civ 1020. The question, however, is whether or not we should do so as a matter of procedural fairness. For the appellant, Ms. Braganza submits that there has always been a duty of candour on the respondent university. Secondly, this is a highly unusual appeal where there has been plenty of opportunity for the relevant issues to be ventilated and the necessary evidence to be adduced. And thirdly, whilst the respondent suggests that more time is needed for the purposes of a substantive hearing, no detail supporting that assertion has been provided. Ms. Lark's position is, firstly, that the duty of candour is staged, such that once permission is granted, more detailed evidence and grounds can be adduced. Secondly, that the respondent is entitled as a matter of right to an opportunity to file detailed grounds and evidence. And thirdly, there are ready examples of the sort of further evidence and arguments that the respondent might wish to adduce at a full hearing, in particular on the argument pursued under section 31, subsection 3. If we were to consider that the matter could not fully be dealt with fairly today, Ms. Slark submits that we could nevertheless today usefully use the time available to deal with a discrete argument based on the availability of an alternative remedy. We have considered the submissions before us, together with the further material drawn to our attention, including correspondence between the parties and the Court of Appeal Office. We've reached the clear conclusion that it would be not be right or fair for a full substantive hearing to proceed today. We take at face value, as we must, Ms. Slarks' submission that the respondent would want to file detailed grounds of evidence and adduce further evidence. And we bear in mind particularly the correspondence between the court office and the parties, where the respondent was told in no uncertain terms that there was no need for the respondent to file detailed grounds or further evidence in the light of the fact that Lord Justice Coulson had granted permission only for permission to appeal. We reject the suggested alternative of hiving off the issue of alternative available remedy for today's purposes, accepting Ms. Braganza's submission to the effect that that submission is one that has to be seen in full context and is not a purely arid question of law that can safely or properly be disposed of separately. We regret our conclusion for a number of reasons. Delay is always regrettable, but in this case we are acutely aware of the effect of delay on the appellant himself in the light of the medical evidence that we have seen. But we nevertheless consider that the only appropriate way of proceeding is by way of a rolled-up hearing. To be clear, we propose the following. Firstly, that there will be at this rolled-up hearing an appeal against the refusal of permission to apply for judicial review. Secondly, if it is concluded that that appeal should succeed, and that therefore there should be permission granted to the appellant to apply for judicial review, the court would then grant that permission and proceed to hear the merits of the matter on a full basis. To that end, we now propose to make directions, having heard from the parties, a loose indication of the window in which this same constitution could hear the matter would be that it could be heard with a one-day time estimate in the week commencing the 29th of April, and our directions should be tailored to that anticipation. So, could we look at directions, please? The first step would seem to be the filing of a detailed defence, detailed grounds of defence, and any further evidence. What timetable would you suggest for that, Ms. Larks? How long do you need?
Might I turn and take instructions from my instructing solicitor?
Yes, and I'm glad to see your solicitor in court. It would perhaps be the right moment for us to raise this point, because it does seem to us, Ms. Larks, it is entirely a matter for you, but that it might very well be advisable for someone else to appear on behalf of the respondent at the rolled-up hearing. You, of course, know better than anybody else what further evidence you might wish to adduce, but it may not be just a question of what the evidence is. It may be the nature of the appeal and the issues that are being raised. If you want to just take that into account when you put forward a proposed timetable, then please do.
Thank you.
Just give me the date of Peter's order here. 5th of July 23. Thank you. For the record, the date of Lord Justice Coulson's granting of permission to appeal is the 5th of July 2023. Anything else you want to? No obvious corrections. I'll tidy it
so
up.
far.
Yeah. Okay.
I mean, just one obvious point to bear in mind is that they'll want to revise their skeleton in the light of the road.
We would propose 4 weeks,
Yep.
taking us to the 26th of March.
And without saying yes or no to that, let's work through where that takes us, because I anticipate, Ms. Braganza, you might want to serve further evidence and an updated skeleton.
Yes, I can see us wanting to file the updated skeleton. I don't think there's any further evidence that there is on our part, but yes, no. But equally, given what we had prepared for today, we won't be needing much time, and we're obviously keen, as long as there's enough time for us to digest what there is in preparation for when the hearing is set, we're ready to go.
Okay. Well, I think you should provide an updated skeleton argument, even if it's identical.
Yes, no,
because,
my lady, of course.
So if we go for, if those steps are taken by the 26th of March, that takes us to the Easter break, I think, is then, and we move into April. So 2 weeks from the 26th of March takes us, please, to what date?
26th of March.
My diary's gone
9th?
bonkers.
9th of April.
9th of April, my lady.
Yes, thank you. That's, I think, literally that's fine. So by updated skeletons on both sides by the 9th of April 24. And that puts us, I think, in good shape for the 29th, the week of the 29th of April. Do we need an updated bundle of authorities?
Yes, certainly, my lady.
If we could have that then by the 16th of April. My lord, a time estimate of 1 day still?
Yes.
While we're on bundles, we would also need, the core bundle would need at least to be revisited, but I don't think anyone would encourage you producing a fresh one. But you might want to put in further pages, for example. Well,
The
obviously
pleading.
the grounds will have to be put
Yes,
in.
we can
They
do
can
that.
be put in a way that doesn't affect the pagination
Yes,
and your revised skeleton, and likewise any evidence.
yes.
All obvious stuff, but
Yes.
work with the existing bundle because we'll have written.
No, I would certainly prefer that, my lord. So I think SB1, SB2 can stay, and detailed grounds of defence and any evidence can just be added to the end of the core bundle. And of course, we'll file the electronic bundles and add whatever the court, if the court needs a replacement bundle with the additional, simply the additional pages will be in the court's hands, obviously. Yeah,
I think the main thing is to preserve the integrity of what we've got so far,
Yes.
because we've marked it up, so it'll be adding A to Z pages
I think
behind
that's
the
easy,
pages
yes.
rather than paginating, please.
yes, there's no problem with that at all, my lady.
That would usually be done at the same time as the updated authorities bundle, or anyway, it needs to be done in a sufficiently in
Yes,
advance
I
of the
mean,
hearing.
I think it preferably that's done at the same time as the updated skeleton so that the skeleton cross-references to the additional documents. I'm not anticipating that there's going to be much. Obviously, I don't know what there is, but presumably relatively short additional detailed grounds of defence, and then if there's witness statements. So, yes, that
Yes.
we can.
So we don't want fresh bundles, we want additional
Yes.
pages to insert into the bundles that we already have.
And we could coincide that with the 9th of April date, my lady.
Yep. Good. And I will direct that the matter be reserved to this constitution, if at all possible. So no absolute guarantees, but we will do everything to ensure that that is the case.
On the listing, if I may ask the court, we know our dates for that week, and in fact we can do the Tuesday and the Wednesday. I don't know if that assists or whether it's for us to liaise with the
I think there's more to be done,
listing.
but if you could liaise with listing within the next,
We can do
24, 48 hours,
Yes, we'll do
please.
that.
And then listing can respond to that by reference to the court's availability as well.
Thank you, my lady.
But I don't. If Miss Slarks needs a little bit of time on the availability
yes, of
point,
course.
I think perhaps a date, and then if that needs to be changed, that needs to be changed. But let's get a date in the diary.
Yes, thank you, my lady.
Anything else, Nick? Anything else? No. Thank you. Not the day that we all expected, but we are where we are for the reasons that we've given. And let's make absolutely sure everything is in absolutely perfect order for swift and efficient dispatch on the next occasion.
Thank you, my lady.
Thank you.
Court riders, if able,